Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. It is May 4th, 2026. The Idaho versus Kohberger high-profile criminal case has been closed for nearly 1 full year. During the pendency of the case for the more than 2.5 years that it proceeded pre-trial, there were a large number of documents that one side or the other filed motions to seal them from public disclosure. On certain occasions, there were stipulations, meaning agreements from both sides that a particular document should be sealed from the public. And if you look at the court docket from the beginning of the case, there is no court order that ever denied the sealing of anything. Everything was granted with respect to non-disclosure of various documents, including evidence from the public. At the end of the case, Judge Hippler announced that he would be looking at the case from July 2025 backwards to the beginning of the case. And what he did was submit 3 court orders to the parties, asking them for their input as to whether or not specific documents from whatever the dates and questions were should be unsealed to the public or should remain sealed to the public. There were 2 court orders that were thereafter issued, one in August of 2025, addressing documents under seal from July and June of 2025, and thereafter Judge Hippler entered an order unsealing certain documents from June and July of 2025 and gave an explanation why certain others would remain under seal. He repeated that process for documents for April and May of 2025, and after hearing from both sides, he ordered certain documents to be unsealed to the public from April and May of 2025. On October 16th, 2025, the court issued the last court order that he has ever issued concerning the potential unsealing of documents from the case. This was directed now at 3 months' worth of documents from January, February, and March of 2025. Amongst these documents were the motions in limine responses and replies that were filed regarding evidence, whether evidence should be withheld from the jury or if evidence should be brought out in the jury trial that was then scheduled to occur in August of 2025. If you look at the docket for the months of February and March of 2025, you will see numerous documents from both sides as to whether in limine before trial the court should order their disclosure to the jury at the forthcoming trial or if they should not be. It ranged from the state's motion concerning the defense's alibi defense to witness identification by bushy eyebrows, should that information be withheld from the jury or should the jury be allowed to see, know, hear about that. Same with IgG DNA evidence. Same with any mention of touch or contact DNA. Same with AT&T timing advance records. Amazon click history. Amazon is where the state alleges Mr. Kohberger purchased the sheath even before he ever left Pennsylvania for Washington, as he did in the summer of 2022 in order to start his first semester as a PhD candidate at Washington State University, and where he worked as a graduate teaching assistant and lived on campus at the Steptoe Apartments, all of which were in Pullman, Washington, located nearby Moscow, where the crimes at 1122 King Road happened on November 13th, 2022, to which no other person but Mr. Kohberger has ever been arrested. Returning to that third and last court order regarding the unsealing of documents, Judge Hippler, in an order that has never been amended, set aside, on December 18th, 2025, stated as follows in the order unsealing, redacting, and or maintaining sealed status of documents numbered 88 to 179. Those were the documents that were referenced in the October 16th court order. It begins on October 16th, 2025. The court issued an order seeking the parties' position regarding the unsealing of the third set of documents identified therein is number 88 to 179. The court has reviewed the parties' respective responses and rules as follows. And then there are three sections of the court order, beginning with Section A, documents to unseal, Section B, documents that would remain sealed, and Section C, documents that would be unsealed but with redactions. Of the documents that were identified in Sections A, documents to unseal without any redactions at all, and C, documents to unseal with redactions, there were 90 documents ordered to be released to the public by Judge Hippler from January, February, and March, including the aforementioned in limine filings that he did order December 18th, 2025. It's been nearly a half year since that order was entered onto the court docket. There's been some filings under seal by the state that appeared to be directed at the court's decision here for reconsideration. But this order of December 18th has never been set aside. It still is in effect today. And if you look at the court docket, only one document has ever been released from this set of 90 that were ordered to be released. And that happened in February when the court unsealed certain documents that were under seal and that related to the defense's reply to the state's in limine filing concerning text messages and phone calls that went in and outside of the property 1122 King Road. There's been no explanation to the public as to why only that document has ever been released. There's been no explanation to the public as to the status of the other 89 and when the public might expect in this highly sealed case, closed almost a full year, with only one person that's ever been charged, when these other 89 documents will hit the court docket. We will continue to keep you posted as further developments arise. Until next time, this is Kathy. Thank you for joining us here today.